Hello and welcome to ProfDale's Property Video number 32. I'm your host, Dale Whitman. In this video, we're going to cover two topics that are related to one another. The first one is equitable servitudes, and the second, which we'll take quite a bit more time on, is common plan subdivisions. Now, in our previous video, number 31, we talked about real covenants, and by a real covenant, we mean one that's generally enforced by an action at law for damages. The rules for real covenants are pretty complicated, and we covered them in the previous video. They are that the covenant's got to touch and concern the land. There must be intent for the burden and the benefit of the covenant to run with the land. We also need both horizontal privity, at least if the burden is to run, we need horizontal privity, and we need vertical privity. And finally, because of the recording acts in the United States, the burden party must have notice of the covenant at the time they acquire the land. Now, the remedies that we talked about, the remedy we mainly discussed was damages, but it's also possible if a plaintiff proves the elements of a real covenant to get an injunction. So either damages or an injunction are viable remedies for a breach of a real covenant. Now, what we're going to do for a moment here is talk about equitable servitudes. An equitable servitude is simply an alternative set of rules for enforcing a covenant that runs with the land. You'll never see a document that says equitable servitude at the top. It's just an ordinary covenant, but if we treat it as an equitable servitude, it turns out that the rules are much simpler. All we need to show is the covenant touches and concerns the land, that there's intent for it to run, and that the burden party has notice of the covenant when they acquire the property. You'll notice what's missing here. For an equitable servitude, we don't need privity. That's the main thing to remember. Privity is simply irrelevant. We may have it, we may not have it, but nobody cares if we are enforcing the covenant as an equitable servitude. Now, that's the good news. The bad news is that the remedy for an equitable servitude, as the name implies, is only the equitable remedy of an injunction. So the plaintiff cannot get damages by using the equitable servitude rules. If they want damages, they have to go back to the rules for real covenants, covenants running at law, and prove, in addition to the normal elements for an equitable servitude, in addition to that, they have to prove horizontal and vertical privity. So that little chart will help you keep straight the requirements for both real covenants and equitable servitude. Well, now, since the same covenant might be enforced either as a real covenant or an equitable servitude, the question is, who gets to choose? Who decides whether it's going to be enforced as a real covenant or as an equitable servitude? The answer is that the plaintiff, the benefited party, the party who's enforcing the covenant, can choose, provided, of course, that the elements of both are satisfied. Normally, if the plaintiff wants only an injunction, the equitable servitude approach is much simpler, and that's the approach that plaintiffs will use. If they want damages, as we said, they've got to go back to the rules for law, the rules for real covenants, and that means that in addition to the other requirements, they've also got to prove both horizontal and vertical privity. That's really all you need to know about equitable servitudes. So now we're going to spend the rest of this video talking about common plan subdivisions. A subdivision, of course, normally is residential. It's a group of houses. It could be townhouses or row houses. It could even be a condominium. But either way, a common plan subdivision has certain specific benefits that are useful in covenant law. And we're going to explore those benefits and see why common plan subdivisions are often helpful to plaintiffs who want to enforce covenants. First of all, what do we mean by a common plan subdivision? Well, there are certain elements that we look for in trying to find whether there's a common plan. First, of course, it's a group of lots or spaces on the Earth's surface. Second, these lots are created by the same developer at the same time. In other words, there's somebody who has formed a subdivision out of a larger piece of raw land. We'll call that person the developer. The lots have to be clustered together, and that doesn't necessarily mean that they have to be contiguous. There might, for example, be streets separating some of the lots from others, but they've all got to be in the same area. Also, they need to be similar in size. If there's a lot that's much, much larger than all of the others, then it's probably going to be considered not part of the common plan. Finally, most or all of the lots have similar covenants imposed on them. Now notice that the language there is a little bit vague. It says most or all of the lots. It could be that the covenants were left out of the deeds to some of the lots, but at least the majority, and preferably a little more than a majority of the lots, do have the covenants on them, and the covenants have to be similar. They don't necessarily have to be exactly identical as long as their general thrust is the same. So those are the things we look for in trying to find a common plan. Now, why is a common plan significant? I'm going to tell you 4 reasons why it's significant, and then we're going to break these down and look at an example of each of them. So you don't need to focus on memorizing the 4 reasons a common plan is significant right now. This is just a little introduction to what we're going to cover. And the first reason a common plan is significant is it defines the extent of the benefited land. Now you'll remember in the previous video we pointed out that very often a drafter of covenants will state what the burdened land is, but will forget to mention exactly what the benefited land is. Well, that's such a common experience that the common plan helps us identify the benefited land. It tells us the difference between the land within the common plan, which is benefited, and land outside it, which is not benefited. Second reason that the common plan is significant is it turns out that it makes the order of sale of the lots irrelevant. That is, a person who owns a later sold piece of land can sue a person who bought an earlier sold piece of land, and vice versa. The order of sale simply doesn't matter, as we'll see. Third, it allows the courts to fill in any gaps in the coverage of the covenants. Suppose, for example, there's a common plan, but some of the lots, a few of them, the developer failed to put any covenant in the deed. Most of the lots have them, but not 100%. Well, the common plan allows the courts to fill in those gaps and impose the covenants on the lots that the developer forgot to include. Finally, the common plan provides notice of those sorts of implied covenants to buyers, so that a buyer who sees a common plan can infer from that there must be covenants that are similar on all of the lots, even though they were left out of the deeds of a few of those lots. The common plan tells the buyer that every lot is going to be similarly restricted. Now we're going to talk about each of those reasons that a common plan is important in a little more detail. The first of those reasons, you'll recall, is the common plan helps us define the extent of the benefited land. To illustrate why that's true, let's imagine we have 2 subdivisions that are very close to one another. In fact, there might just be a single street separating them. We have subdivision A and subdivision B, and each of them meets the definition of a common plan that we talked about on the previous slide. So we have a common plan for subdivision A and a common plan for subdivision B. Each of them, however, is its own common plan. They're not part of the same one. Now, what the common plan tells us is that any lot owner in subdivision A can enforce the covenants against any other lot owner in subdivision A, so that lot owner 1 could sue lot owner 6, or lot owner 6 could sue lot owner 1. No big surprise there. It only makes sense to suppose that each of the owners can enforce the covenants against the other. However, the lot owners in subdivision A cannot enforce the covenants on the lots in subdivision B. It's a different common plan, set up by perhaps a different developer, but certainly at a different time. So what that means is that if someone in subdivision B violates the covenants, nobody in subdivision A will be able to enforce them against the violator. And the same, of course, is true in the opposite direction. If there's a violation of a lot in subdivision A, the folks in subdivision B won't be able to enforce those covenants. So each common plan's lots are the benefited land for the covenants that burden the lots within that common plan subdivision, but not other subdivisions. Each of them is considered a separate entity. Now, a second important use of the common plan is that it makes the order of the original sales of the lots irrelevant. Let's take a look at subdivision A for a minute and assume that the lots are sold in numerical order, starting with lot 1, then lot 2, lot 3, and so on. And as each lot is sold, a covenant is placed in the deed of that lot. Now, that's not always the way the developers do it, but let's assume that's true because it makes it easy to keep track of our present problem. Okay, so owner 5 can enforce the covenants against lot 1. Why? Well, normally we assume that when someone sells a lot and puts a covenant in the deed, the benefited land for that covenant is the land that the developer still retains, or the seller still retains, in the area where the lot sold is located. So in this case, when the developer sold lot 1, the developer still had lots 2, 3, 4, 5, 6, 7, 8, 9, and 10. And therefore, all of them became the benefited land for the covenant on lot 1. And lot owner 5 is just a person who bought a chunk of that benefited land. So it's obvious that owner 5 can enforce against lot 1. Owner 5 has benefited land with respect to the covenant on lot 1. Now that part is simple and we don't need a common plan to figure that out. However, let's suppose the tables are turned. Suppose owner 5 violates the covenant and owner 1 wants to sue. Now this presents us with a bit of a dilemma. We normally, as I said, assume that when a lot is sold and a covenant is placed in the deed, the developer's retained land, the land that the seller still has, is the benefited land. However, in the present situation, when lot 5 was sold, the developer didn't still have lot 1. Lot 1 had already been sold to somebody else. So how can we say that the owner of lot 1 can enforce the covenant against lot 5? However, the beauty of the common plan is it says that's irrelevant. Everybody can enforce the covenants on everybody else's lot, and it doesn't matter whether the plaintiff's lot was sold before or after the defendant's lot. So there's total mutual right to enforce the covenants within the subdivision. So it doesn't matter whether the plaintiff's lot was sold before or after the defendant's lot. That's the beauty of a common plan subdivision. By the way, when the courts explain why they follow this approach, they sometimes say that in the situation of the third bullet point here, where owner 1 is enforcing against lot 5, they sometimes say, well, owner 1 is considered a third-party beneficiary of the covenant on lot 5. Even though lot 1 wasn't still owned by the seller when lot 5 was sold, that doesn't matter. The person who bought lot 1 is considered a beneficiary of the covenant on lot 5. The third reason that the common plan is useful is because it allows us to fill in gaps in the lots in the subdivision. Let's suppose in subdivision A here that the developer puts the covenants in most of the deeds as the lots are sold. I've indicated those lots by coloring them blue in the diagram. However, the developer leaves out the covenants in a couple of those deeds. Lot 2 and Lot 6 aren't colored blue because those are the lots where the developer left out, forgot to put in the covenants in the deeds. So we might say, well, that doesn't leave a suitable situation here. It isn't fair for some people to be subject to the covenants in the common plan while others are not. But the equity courts say, don't worry about that. We'll simply imply the covenants in the deeds that are missing them. If there's a common plan, every lot is considered to be similarly burdened by the covenants, even though literally the developer left out the covenants in a few of the deeds. Now, there's a fancy name for this. It's called a reciprocal negative easement. But don't be put off by that. A reciprocal negative easement is just a complicated name for an implied covenant, one that the courts will read in even though it isn't literally in the deed. Why does it get the name reciprocal negative easement? Well, a negative easement is simply a covenant. Just as a positive easement is the right to do something on somebody else's land, a negative easement is a prohibition on doing something on somebody else's land. And these implied covenants are considered to be reciprocal in the sense that what's sauce for the goose is sauce for the gander. That is to say, if the blue-colored lots owners are all subject to the covenant, reciprocally, it only makes sense that the white-colored lots should also have the covenants imposed on them, so that everybody is treated equally. Those implied covenants on lots 2 and lot 6, those reciprocal negative easements, raise an interesting problem. Suppose you were buying lot 2 or lot 6. How would you know about the implied covenant? You wouldn't find out about it by doing a title search because, as we've already said, the deeds of those lots don't contain the covenants. So let's assume the covenant we're talking about is one that provides that the lots may be only built with single-family houses. That's a very common type of covenant. Well, if you were buying lot 2 or lot 6, you would look around and see the actual houses on the other lots, assuming they were built there, and that would tell you, supposedly, oh, well, there's a common plan here, and that must mean that lot 2 and lot 6 are also burdened by the covenants, even though they're only implied on those particular lots. So the common plan as built, as actually developed on the ground, is thought to tip off a buyer that the subdivision is a common plan, and therefore that all of the lots are similarly restricted. Now, this idea that one can look at the subdivision as built and get notice of the reciprocal negative easements or implied covenants has some very serious limitations built into it. It mainly works with the covenant that we started with, that is one that says residential only or single-family dwelling only, that type of covenant. It doesn't work, of course, unless most of the lots have actually been built on in compliance with the covenants, because it assumes that one can look at the subdivision and see the effect of the covenants on the ground. If the covenants are there, but the lots are still vacant, then the theory doesn't work at all. It also doesn't work with more fine-grained types of covenants. For example, suppose you had a covenant that said no satellite dishes could be placed on the houses, or there could be no shingle roofs, or there could be no parking of recreational vehicles, or no fences higher than 4 feet. Those are all actually very common provisions of modern covenants, but could you really get any notice that satellite dishes are not allowed simply by looking around and not seeing any satellite dishes? Well, that's a nonsensical idea. Obviously, the absence of things like that doesn't prove or even suggest that they're not allowed by the covenants. So the only kinds of covenants for which this theory really works are covenants that say residential only or single-family dwelling only. Finally, this notice theory for the reciprocal negative easements probably works only in equity, that is, where the plaintiff is seeking an injunction, and probably does not work at law where the plaintiff wants damages. Now, fortunately, in most cases, plaintiffs in these subdivision disputes do want injunctions, and so the theory is fine for them. But be careful not to apply it at law, because the courts generally have not been willing to do so. Now, this reciprocal negative easement or implied covenant theory is really designed only for careless or stupid developers, and only a very stupid developer would rely on it. Instead, what the developer would do if the developer were more careful is A, be very careful to put identical covenants in the deed of each individual lot. Make sure the covenants are all alike and that every single deed includes them. But there is actually a better way than that to do it, and that is for the developer to record a written declaration of express covenants, put that in the public records, before any of the deeds are delivered, so that that declaration will govern every single lot in the subdivision. Now, the declaration would look something like this. Conventionally, they're called CC&Rs, which stands for Covenants, Conditions, and Restrictions. Incidentally, that's a little bit of a misnomer because there really aren't any conditions. They're simply covenants that impose restrictions. But nevertheless, the term CC&Rs has come into very, very common use. So the idea is that this declaration of CC&Rs will be recorded in the public records before any of the lots are sold, and the advantages of that are twofold. First, it saves having to copy the covenants into every deed. Now, in the old days, when the covenants were just a sentence or two long, that wasn't a big burden. But today, covenants often are many pages long, and it would be extremely burdensome, and the deeds would become extremely voluminous if the covenants had to be placed into every deed. Well, the declaration of CC&Rs avoids having to do that. The other advantage is it assures that all the lots will have exactly identical covenants, that there won't be any variation among them at all. And that's good in terms of fairness to the lot owners, and of course also in terms of establishing the existence of the common plan. So how do we make that declaration of CC&Rs, covenants, conditions, and restrictions, how do we make it enforceable against the lots? Is it enough to record the declaration itself before any lots are sold? Many courts have said, yes, that'll work fine. That's all you need to do. The declaration will state that it governs all of the lots, and therefore, when each lot is sold, it's automatically covered by that previously recorded declaration. A second approach is a little more specific. This means that we would put in each deed a statement that says, title is subject to all covenants, conditions, and restrictions of record. Now, that doesn't specifically identify our declaration, but it does tip off the buyer of the lot, the person who obtains the deed, that there may be some declaration of CC&Rs that will be affecting that lot. The third way to do it is to incorporate the declaration into the deeds very specifically by saying something like this in each deed. Title is subject to that certain declaration of covenants, conditions, and restrictions recorded in a certain book and on a certain page of the official records of a certain county in a certain state. Certainly this is the best and preferable way to do it, but number 2 will also work, and in most states probably number 1 will work. That is, without any specific reference in the deed to the declaration at all. There is, however, a good reason to mention the covenants in the deed, either generically or specifically. And that reason is that if it's a warranty deed, a deed that contains a warranty of title, and it doesn't contain any limitations on the coverage of that warranty, then the warranty is going to be breached by the existence of the covenants. The grantor is therefore, in theory, liable for damages for breaching the covenants. So the grantor will surely want to mention something in the deed about the possible existence of a declaration of covenants in order to forestall being sued for damages for breach of the warranty. Either method number 2 or number 3 on the previous slide will eliminate this problem, but if you're drafting deeds for a developer, don't forget to include either a generic or a specific reference to the declaration that you've previously recorded. Well, that wraps up video number 32 about equitable servitudes and common plan subdivisions. In our next video, number 33, we'll talk about some of the problems of applying and construing covenants in the real world. If you have questions or comments, email ProfDale01@gmail.com, and thanks for watching.